Good morning, Your Honor. Kate Benvenisti of Greenberg Traurig, appearing for plaintiffs and counter defendants, and with me is my colleague, Zach Levy.
Good morning, Your Honor. Ryan Lorenz on behalf of defendants.
All right, welcome to you all. We're here for a Rule 26D conference. I received the updated joint statement of disclosure dispute, and I kind of went through the list of relief. So what I wanted to do was just talk through each of the issues. The first of which is the ESI protocol order that was proposed as an attachment to the updated joint statement. And the suggestion was that the parties had agreed to that ESI order, but I wanted to confirm that.
Well, from plaintiffs, Your Honor,
Your Honor.
Sorry. So I'm hearing from both of you that yes, you agree to the stipulated production protocol that was attached as Exhibit A to the updated joint statement.
That's my understanding, Your Honor. That we heard for the first time from defendants yesterday when they submitted their portion of the joint statement to us that they were in agreement with the protocol, and Mr. Lorenz, I believe, just confirmed that on the record here. Our challenge now is that the documents we received from defendants for the first time yesterday, and actually on Tuesday and yesterday, don't comply with that protocol.
Okay, and we'll get to that, but so here's what I want to do, because I don't want to have to separate out myself the portion that's an attachment to the updated joint statement. So I'm going to set a deadline for you to file a stipulation that includes your ESI protocol order uploaded as a Word document so that I can then just get it entered in our e-file system, which is easier. But I'll note for the record that the parties have already stipulated to it. How soon can you get a stipulated proposed order to me? And by that, you can just do a notice of filing stipulated proposed order and have it uploaded as a Word document. That's really all I need.
Plaintiffs can do that today, Your Honor.
Okay, so how about this? I'll give you till tomorrow to get it to me so that I can get it entered. So it is ordered that on or before Friday, August 21st, 2026, the parties shall jointly file a notice of lodging proposed ESI protocol order pursuant to their stipulation placed on the record and confirmed today, and the court will enter that order upon its receipt. Okay, so then let's talk about the production of ESI. So part of why I entered the order that I did is that I wanted you to have a genuine meet and confer that's required on Rule 26.1C1, and to develop the protocol. And then after that point is when I can compel compliance with the protocol. So while I understand frustration that there was delay in agreeing to it and that there's been a production that doesn't comply with it, the order isn't yet in place, and it really isn't until recently that there was agreement to it. So, Mr. Lorenz, I'm going to put this to you. I don't know if there's more production coming and what your response is to the objections that the documents that you more recently produced do not comply with the protocol. And I'm guessing that's because they're not in the right format or they're not OCR'd or what have you.
Your Honor, when we met, what I provided to Ms. Benveniste was a screen share of the precise set of documents that I was provided by my client. They're organized in folders, but the individual documents that have been produced thus far, which are about the same quantity as the plaintiffs have sent us, so we're up to over 20,000 pages we produced. they're produced in the order that the documents appear in the folders that we showed the plaintiff. And so when we complete the production, we will go back and we will make sure the plaintiff knows where the documents come from, what folders they were located in, and they've already seen those folders. So, but what the plaintiffs wanted was documents. We numbered what we had. We conducted our privilege review and started producing them as quickly as we could. Considering the fact that we've produced almost the same quantity of documents as the plaintiffs, and basically, in the same format, what we've gotten has not been. By the way, we did find out from one another that we use the same document management software, Relativity, and so we'll be able to communicate better once documents are loaded into that medium. So I think we're on the right path. I'm sorry, Ms. Benveniste is shaking her head, so I'm sure she has something else to say about it. But I mean, the fact is we're basically dead even as far as what we've produced, and certainly we'll comply with the order when it comes down.
Let me ask you this. So you've now stipulated to the production protocol that I'm going to be getting entered at some point when I receive, and there may be some lag in my getting it because when you e-file something, it doesn't automatically pop up. The clerk still has to process it, and it's all kind of within their control when it comes to me. So don't panic if you don't see it entered right away. But that said, you've stipulated to it. So, and I understand there's a large volume of data to get through, but can you give me an idea of, number one, whether you intend to go back, and maybe I'm misunderstanding, but I think what you're telling me is you wanted to get them whatever you could in the format you had it, which is why you produced what you did in that format, even though it may not comply with this protocol, but that you have the ability to reproduce it in compliance with the protocol. And we'll be doing that in the future, both as to the documents already produced and the additional documents you intend to produce. Is that accurate, or am I misunderstanding?
That's correct, Your Honor. Yes, you said it better than I did.
Okay, well, I'm glad. Sometimes if I repeat it, then I can make sure I'm understanding what's going on in the process. So where are you in that process, and when will you be able to produce in the format required by the protocol all of the documents that are subject to disclosure under 26.1C2?
So, I mean, the volume of them, the only snags that we're running into are a few password protected documents, and we flagged those to be opened and sent over. There are no state secrets or anything. They're documents that both sides have had access to. It's just that when they were sent to us, they still had the password metadata on them. But I think it's going to take us, we're going to probably need the remainder of this month to get that done, Your Honor.
Okay, this month means August, which we only have, amazingly, a couple weeks left in. Because that, I will tell you, Ms. Benaviste, that when I saw your 5-day order, I thought that was way too ambitious, given that you just really, really recently came to an agreement on the ESI protocol order. And I understand that you've been pushing for this for some time, but you're at a place now where we're going to have an order in place, and I can set a firm deadline today, but I'm not going to set a deadline that's impossible for them to comply with, because I'm just setting them up for failure, and that's really not my goal. My goal is to get you both the information that you need within a reasonable time so that you can move forward with the merits of the case and not be bogged down in these disputes and technical issues. So, Mr. Lorenz, if I were to give you till a couple of weeks, that would be September 4th. And if I set that deadline today, that's going to be a firm deadline. That means you comply with 26.1C2, you produce all the ESI data you have available and aware of, and that it be produced in the format. And that would mean going back and reproducing what has been produced in the correct format under the protocol order. Is September 4th a workable deadline for you?
Yes, Your Honor.
Okay. Now, Ms. Benavides, I know you have something to say, so I'll give you that chance to. Go ahead.
Thank you. I appreciate that. There are two issues here. Now, today, there is an issue about format, but initially the issue was about the production of documents to begin with. As we all know, the rules require the parties to produce their documents and data within 40 days of their initial disclosures. As the court is aware, we went through quite an effort just to get the initial disclosures from defendants to trigger the 40 days for defendants to produce their documents. Long before Mr. Lorenz was counsel for defendants, and it was Mr. Bodie at Tiffany and Bosco, when Mr. Bodie and I and Zach Levy had our initial meeting, we discussed at the outset the things that we were required to discuss as part of that early meeting, including what we anticipated about ESI, productions, where documents were stored, et cetera. And from the beginning, it was discussed and agreed that we were both going to be producing documents in what I will call a database ready format, right? Which, Mr. Lorenz is an experienced practitioner. We all know what that means. That means documents are going to be ingested into a database that people can review. Those discussions were memorialized in a writing that Mr. Bodie and I exchanged. And then when Mr. Bodie withdrew, I forwarded that to Mr. Lorenz immediately and invited him to meet with me to discuss how this case was going to go. And as the court can read and has been detailed in prior statements from plaintiff's counsel, those were not met with a willingness to really have any discussions. And so the issues then shifted to just getting documents in any format. And even if the parties had not agreed on an ESI protocol, the rules at a minimum require documents to be produced in a reasonably usable form. And so the absence of an ESI protocol, which had not at that time been ordered to be agreed between the parties, didn't obviate the obligation of defendants to produce documents within their 40-day timeline after serving their initial disclosures. And as a reminder to the court, plaintiffs served, I should say, their initial disclosures before defendants because defendants didn't meet the deadline. And so plaintiffs have been making productions on an almost a weekly basis in a database ready format that actually complies exactly with the protocol that we proposed for 2 months. And we've been doing that on a regular basis for 2 months. So it shouldn't have been a surprise, and it's no excuse on defendants' part to say, to the extent they're suggesting that they hadn't produced anything because we didn't agree on an ESI protocol, that's not actually accurate. Defendants have been promising to produce documents all along and then not meeting those deadlines and then not communicating why they're not meeting them. We only got to this ESI protocol place after our most recent statement of disclosure dispute where Your Honor ordered us to meet on a protocol, which we did, and agreed on what the parameters of that would look like. I drafted it and sent it to Mr. Lorenz, and then still 2 weeks later, we are receiving documents not in that format. What we received on Tuesday were 10 PDF files that are unsearchable of thousands of pages of documents. They're not unitized. There's no metadata. In fact, most of the time my computer can't even open them because in some instances, these PDFs are 1,500 pages long with no breaks between documents. You don't know where one starts and one ends. And then yesterday, we got another production of 10 PDFs. So far, I have 20 PDFs consisting of over 20,000 pages between them that I cannot ingest into a database to review. It is not usable under any format. It is just completely not usable, period. So I appreciate that Mr. Lorenz wanted to produce something to be able to tell the court that defendants made a production, but it's really no production at all because most of it can't even be reviewed. So we will have to wait till September And that's fine. We'll accept the court's date. I'd rather get the documents in the format that we agreed. But in the interim, we're not really going to be able to do anything with what we've received. And I've seen Mr. Loren's, complaints in his statement that we're playing the quote annoying game of I don't have to ask you for it. You have to disclose it to me. That's exactly what the rules require. We've all been practicing in this jurisdiction for a long time. We know those LACIT rules. We know 26.1. The whole point of this is to not have to ask. It's for the other side to automatically produce what they're obligated to produce under the rules. The idea is to nearly eliminate the need for written discovery, if at all possible. And then to the extent you do need to use written discovery, you can narrowly tailor that to, quote, flesh out the bones of voluntary disclosures under 26.1. That's, bedrock Arizona interpretation of the case law, interpretation of the rule. It has been, and I'm not overstating this when I say this is the most difficult and frustrating case to obtain disclosures in my nearly 18 years of practice here. It absolutely has been. And here we are. This case has been pending for almost 1 year. And we just got documents, sort of, 2 days ago, which consist of PDFs that are virtually unusable. 20 PDFs. That's not a disclosure.
Okay. Anything else?
That's for now all I have to say on that.
All right. Mr. Lorenz, any response?
Well, Your Honor, I guess, first of all, Tom's LACIT doesn't even like his name assigned to those rules because of how the rule has evolved in practice. And this is a situation which is rather loathsome, primarily for the court, since the plaintiffs have filed, I think, 3 or 4 different iterations of the same thing. We want documents. First of all, on the technical level, my knowledge, the documents that loaded and shared with the plaintiffs were searchable and usable in whatever format. I didn't hear that until just now, and I would be surprised if Ms. Benveniste and her team have reviewed everything. But nonetheless, I mean, the bottom line here is the lawyers just need to talk, which is why in our last memorandum, we proposed that the court order monthly in-person meetings to discuss these matters. No phone calls, no Zoom meetings. We have to get up out of our chairs, go across town or across the way to one another's offices and discuss these things productively. And I think that would work. I know the plaintiffs have suggested discovery master, but I mean, mature and experienced attorneys can usually handle these things. If an in-person meeting helps, which I think it does, I'm perfectly happy to do that. And I'm seeing Ms. Benveniste cringe, so perhaps that's not well received.
It's because it sounds nice in theory if that's what was actually being proposed. But our challenge is, number one, virtually every time, with rare exception, when I have reached out to Mr. Lorenz, he does not respond. Virtually every time. I'll give a great example of that, which is, well, I mean, again, Your Honor can read and see example after example in our papers. Every instance where we called, emailed, reached out, said, hey, do you have comments to this? Can we meet and confer? When are you available? I have never once received an email back from Mr. Lorenz saying, here's when I'm available to meet. Instead, what I have received on 2 occasions are a unilateral calendar invite for a date and time picked by Mr. Lorenz, both of which I accepted. The first time it had no meeting format, so I didn't know what the expectation was. So I immediately reached back out to him and said, how do you want to handle the meeting? Who should call who? Are we going to do it by Teams or by Zoom? He didn't respond to my email. I called him. He didn't call me. I called him at the time he said. He didn't answer. He says that it's because he didn't recognize my phone number. Well, then what was he doing? Just sitting there waiting for who to call whom? And when we did finally have our meet and confer, I said to Mr. Lorenz, what was your expectation? Because clearly I'm not understanding what you meant when you unilaterally send the calendar invite with no information, and he didn't have an answer. Again, it's just to say that he made the effort, but not actually to meet and to talk. And the reality is the 2 times we have spoken, he doesn't follow through on anything he says. He says he will produce something by a certain date in a certain format, and he doesn't do it. This is why we are here.
Okay, here's what I'm gonna start by saying, and it's true generally of all of the cases where I have multiple discovery disputes being filed, which frankly is much higher on the commercial calendar than what I experienced on the general civil calendar, which is sad to me because the expense and the hourly rates that clients are paying to commercial lawyers are very, very high. So that to me should indicate be a motivator to try and minimize how much time you spend on that, but it's just the reality that these are high conflict cases. That said, I don't condone a lack of communication. I do think that when you're having trouble communicating that it helps. That's why I ordered you to do it in person or by video conference, because I think people tend to shoot off nasty emails. It's a lot easier to be dismissive or curt to someone by email, or to just not really focus in on what needs to be focused in on. But when you're face to face with someone, you're much more likely to be polite. You're much more likely to be focused and paying attention to what you really need to pay attention to have a meaningful, good faith consultation. So here is what I'm going to do. I understand, Ms. Benavides, your frustration that you have said, hey, I have my client and I have done a tremendous amount of work to comply with the disclosure rules, and there shouldn't be a different standard for the other side. And they haven't. There's been a lot of delay associated with it. I don't condone that. And what I will say is that going forward, I'm going to have to come down harder and harder if this kind of pattern continues. And I don't want to have to do that. I would rather you all be, if you have issues, I want you to bring them to me, but I want them to be issues that pertain to the merits. If you have a dispute over whether something is privileged or something is relevant, those are the issues I want to be able to work through, not a lack of communication altogether, because that's really not something that should have to be brought to my attention. So going forward, this is our reset. I'm going to set specific deadlines. And if this pattern continues, I'm going to have to start imposing sanctions, and the sanctions are going to get worse after today if there's not a change in course of how this proceeds. That said, there are always problems when there are changes in lawyers, and it's difficult for me to fault a new lawyer coming in when there's already been delay in getting things going. And I do see that Mr. Lorenz has made more progress over the last couple of months than was previously made. And I'm now, as I said, setting a very firm deadline that you have those documents in hand in a usable format according to the protocol. And if you don't get those documents on the 4th, I will authorize you to leave to file a motion for sanctions. And I will grant sanctions if there has not been compliance with my order today. And that's 2 weeks away. I know it's 2 weeks too long when you've been waiting too long as it is, but it's a firm deadline that I am not going to be flexible on. So that will hopefully resolve the issue of the document production or disclosure under C2. You will have other issues. Once you get through that initial production, you're both going to have follow-up you're going to want from each other. So that does mean you're going to need to do a better job of communicating with one another going forward. I typically don't like to micromanage your litigation because you can do this on your own. My thought is that rather than requiring you to meet in person every month, because that just may not be necessary. And as I said, you're fully capable of determining when you need to meet and when you don't. But what I am thinking is, number one, I'm going to enter a specific order for this case that if either party contacts the other party requesting a good faith consultation on any discovery matter, that a response with available dates be provided within 3 business days of receiving the initial communication. Because the other thing I see quite frequently is that someone will email and say, I need to have a meet and confer tomorrow. And then if there's not a response, they go ahead and file a unilateral statement. You're all busy. You have to give the other side a reasonable amount of time to respond to you. But here, I'm just going to go ahead and set a deadline that if you get an email requesting a meet and confer, you've got to respond with available dates for the meet and confer by email within 3 business days. And so within 3 business days, if you don't get the email response saying I'm available on X, Y, and Z date, then I will authorize you to file your unilateral statement. But the initial request for a meet and confer also needs to contain the subject matter of the confer. So you should, if you reach out requesting a meet and confer, you should say what it is about, when you're available, and request dates from the other side for their availability. The response to that request must be filed within, or not filed, must be provided the other side with, I'm guessing you're doing this mostly by email, so you have a record, but the response should be within 3 business days. The meet and confer itself, I'm always hesitant to make you meet in person because while I do think, frankly, I miss having you guys in court physically here more often because it's just nicer to communicate with a human than a screen. But I also recognize that we have this technology available that allows us to see and speak to each other in a way that's more convenient and less expensive for your clients than driving across town. So what I will do is require that all meet and confers going forward be by video conference or in person, and I'll leave it to you to decide which of those options you want to choose. But the party requesting the meet and confer will be responsible for making the arrangements, either providing a space to do the meeting in person or setting up the link to do the video conference. And at least that way you will have some flexibility in how you meet, but you will both be looking at each other. And, you can't be typing and responding to emails, and doing other things when you're supposed to be focused on this one thing. So I will enter that as a supplemental order in this case going forward. The other thought I have is that because you're going to be getting a big tranche of documents from the defendants on the 4th, that maybe right now we can go ahead and set, if you have your calendars available, a time for you to meet and confer after that production. That way, if you have follow-up, you will already have a time on your calendars set aside to do that. And I don't know how, it sounds like it's a pretty large chunk of documents and both sides may have things to go through. So you tell me after the 4th when you think it would be reasonable to expect that you've been able to get through all of the data produced and have a meaningful meet and confer.
Depending on the volume, but based on what Mr. Lorenz said we should anticipate, I don't know that we will do a hand review of that much that quickly, but I think we can at least do a survey of what we've received and identify issues within 2 weeks or so from receiving the production.
I was thinking
we won't have, okay, that would be fine.
I was thinking 30 days just because I always I'm overly ambitious about when I can get something done. And I think it makes sense to give yourselves a cushion. 30 days will be, last week of September-ish, first week of October. Do you, in those 2 weeks, maybe September 28th and the week of October 5th. Do you all have any time that works best for you to just, I'll set the date in my minute entry, and you can tell me if you want to do it by Zoom or video conference or in person.
Zoom is fine. I would suggest Tuesday, September 29th.
Mr. Lorenz, what does your calendar look like?
The 29th. Yeah, the 29th is fine.
Do you have a specific time?
I'm available.
Yeah, we've got a noon meeting. Nothing I can't move. So 2 o'clock in the afternoon is fine.
Perfect.
Will that work for you? Okay. So it is ordered that the parties shall conduct a meet and confer at 2 p.m. on Tuesday, September 29th, 2026, following the production of additional ESI from the defendants on September 4th regarding any follow-up issues related to disclosure or discovery in light of that document production. The parties will do that by video conference. And Ms. Benaviste, do you want to take the lead on sending an invite to Mr. Lorenz through your video conferencing system?
I've already done it. It is sent.
Okay. All right. So great. So that is the only one I'm going to schedule for you. What I am going to say is, going forward, the parties will follow my protocol on submitting a request for a meet and confer with the subject matter of it and a response within 3 days. And any conferrals should be done by video conference or in person going forward. Of course, you can bring issues to me. So let's try that, because I appreciated the request for the appointment of a discovery master. And I've seen that done a lot more on this calendar than in past calendars, but I also know it's just another expense that can become significant. And I haven't seen that it necessarily moves cases along faster. Now, don't get me wrong. If it gets out of control where I'm getting 5 discovery disputes every other week, which I have cases that are like that, then it just sometimes becomes necessary. But I don't think we're there yet. I want to give you guys a chance to kind of change the course of this case, move it forward without that. And if you need to come back to me and request it, you can, and I will consider it. But I don't want to jump to appointing a discovery master just yet, unless you tell me you both really want that. If you both tell me you want that, then I will do it. And you can submit a list of names to me.
I think a discovery master would be very helpful, because then we can, as issues, but not necessarily, significant disputes, but whether it's over a privilege question or where documents are located or things of that nature that we need someone to help us get through, I'd rather not bother the court with those issues and instead go to someone who, not that your honor hasn't made herself available as we need, but that we can, sort of have free access to help us work through those issues that I anticipate are going to come up. And again, we flagged, I think, even in our I can't even call it a joint report, plaintiff's report that we filed last spring, that we knew this was going to be an issue, and it has continued to be. And I unfortunately, while our communication might improve, I don't expect the issues that we're going to have are going to go away in terms of where documents are in scope. I mean, even as of the last time Mr. Lorenz and I conferred, there was still uncertainty on his part about what his client actually had possession of and what types of documents and where in the systems. And those were things that we expected defendants to have knowledge of from our first meetings. And then there's still a question mark there. And I think we're going to continue to run into those issues.
Okay, fair enough. Mr. Lorenz?
It's a couple points here, Your Honor. I really, like to approach these things with a more optimistic attitude and outlook than I'm hearing. And so, as far as the special master is concerned, this is a 7, I don't know, maybe an 8-figure case. Maybe somebody thinks it's 8. I think it's a 7-figure case. That doesn't mean that you go spend wildly on a discovery master just because things got off to an admittedly poor start. So I'm opposed to it. I don't think the expense is worth it. And I sort of hone in on something Ms. Benveniste said, which was, we're sorry we had to bother you. Well, so is the point of the discovery master to have someone else to bother? I think we should be judicious in how often and for what level of seriousness we invoke any authority of a court or a master, because this is getting us nowhere. I think what a lot of lawyers forget is the court hears trials 4 days a week, and yet we spend 4 days a week doing other things, and we're not focused on trial. We're focused on silly things like, is the document OCR? Is it, so I guess I hate seeing us get wrapped around the axle when we've not said one word about the merits of the claims or defenses here. We got to move on. We got to get past this.
Well,
and I have every belief that we will.
Plaintiffs would love to get to the merits, and having documents that allow us to assess the case and move on to other phases of discovery are sort of a predicate. And that's where we've sort of been stuck for the last several months.
Okay, here's what I'm going to do. Because there's not agreement on the discovery master and it would add to your expense. Plus, I want to see where you are after you get this initial big tranche of documents. So I have 2 options. I can either let you do your meet and confer on September 29th and then come back to me if you have Rule 26D disputes and a renewed request for appointment of discovery master, and we can revisit it at that time. Or I can go ahead and set a status conference right now just to have it on the books to meet with you after the 29th, which I'm happy to do. And we can talk about how things are going and whether at that point, if you have issues, you can let me know what they are. And we can also talk about whether you still feel like a discovery master is something that would be helpful to you.
Plaintiffs would suggest that you set a discovery conference now, Your Honor, and if for whatever reason the parties agree that it's not necessary, we can ask you in advance to vacate that.
Okay, I'm fine with doing that. And I don't think it's necessarily a bad thing, just so I can keep an eye on how things are going. All right, you're going to meet on the 29th. I want to give you enough time to get a report to me, a status report to me after your meet and confer and before our hearing. So I am going to set you, let's see. Are you all available for a virtual status conference on October 9th at, let's see, I've got a final trial minute, at 8:45 a.m.?
Plaintiffs are available.
Yes, Your Honor.
Okay, so I'm going to schedule a status conference in this case to discuss any outstanding discovery disputes and whether or not the parties have, I'll ask you to also confer about the discovery master issue again after you've gone through the documents and at your September 29th meeting. So we'll discuss those things on the 9th at 8:45 a.m. We've been going for over 45, well, we started late, so let's reserve 45 minutes on the calendar just to be on the safe side, Veda. And what I'll ask you to do is just submit a joint status report to me, identifying any discovery disputes following your meet and confer, anything you need to talk to me about on the 9th. That way I can just be ready for it, including whether or not you are renewing a request for the appointment of discovery master. If you're going to do that, though, make sure you also talk about who you might want to have appointed and reach out to them to make sure that they're available. That way, if we are going to, if that request is renewed, we can get an order in place with someone who's willing to take it on and available. So I'll ask you to file that joint status report on Monday, the 5th, because it's so close in time to the hearing and I have no control over when things get docketed. Please email your joint status report to my division at CVJ19. I'll include that email in my minute entry today. So the last thing that I wanted to talk with you all about was the request to sort of pre-exclude any undisclosed evidence that doesn't comply with our protocol and the request for attorney's fees and costs. As far as excluding evidence, I don't typically enter kind of a preemptive order on evidence. That is without prejudice, of course, to you coming back to me and saying there was something late disclosed or something not disclosed or something spoliated, but I really need a specific piece of evidence that you're talking about before I can rule on whether or not something is excluded, because I have things that I have to evaluate under Rule 37 that are not just it was late or it wasn't in the right format. So I'm denying that request without prejudice. I am also at this point denying the request for sanctions in the form of attorney's fees without prejudice. Again, it's because I'm setting firm deadlines and firm expectations today. And while I don't condone what's happened in the past, I am sending the message today that going forward, that's not going to be allowed to continue. So it's without prejudice to requesting an award of fees if these sorts of issues continue to arise, and I hope they don't. So is there anything else we need to talk about today that I've missed?
Not from plaintiffs, Your Honor.
Your Honor, my only remaining concern is that that things not get filed with the court when there's no reason to. In other words, the sanctions or the possibility of sanctions should be a two-way street. So if someone cries wolf and there's no there, or there's no issue, or it's a waste of the court's time, and maybe that's what the court thinks of today. I don't think it was. I think it's been very helpful, but I also think that's, a motion or an issue raised that creates expense that was unnecessary may receive the same admonition, the same possibility of sanctions.
Well, I will tell you what I told the last discovery dispute I had this week, which is I'm always going to, if we can't get it resolved in a 26D hearing, I will give parties leave to file motions. But if we get to the point where I'm seeing full briefing on a motion on a Rule 37 or any of the discovery rules, somebody's going to get sanctioned. The party who does not prevail is going to pay the other party's fees. And that is why, or that should be the incentive to not have to get to that point. And of course, that doesn't apply to things that are genuinely matters of law, like is this protected by the attorney-client or work product privilege. But when it comes down to objections that can be resolved by agreement and aren't, I will let you file those motions, but it does go both ways. And that's why I'm saying I hope that it won't get to that point. But if it does, someone's going to have to pay the other side's fees. All right. But we don't need to get to that point because we've had a good conversation today. You've got a plan for getting these documents produced in a format everybody can review. And you're going to meet in less than a month, and you're going to see me a week after that. So there won't be any more delay because there's a firm plan in place. Okay? Or at least that's my hope.
Thank you, Your Honor.
Thank you, everyone. Have a nice day. We're off the record.